Questions and answers on political law, Part 2. Question: what are the three kinds of initiative under RA 6735? Answer: 1. Initiative on the Constitution refers to a petition proposing amendments to the Constitution. 2. Initiative on statutes refers to a petition to enact a national legislation. 3. Initiative on local legislation refers to a petition proposing to enact a regional, provincial, municipal, city, or barangay law, resolution, or ordinance. Section 2A, RA 6735. Note: Section 2B of RA 6735 provides for 1. Indirect initiative, exercise of initiative by the people through a proposition sent to Congress or the local legislative body for action. 2. Direct initiative, the people themselves filed the petition with the Cumlic and not with Congress. Question: what is the rule on local initiative? Answer: in case of 1. Autonomous regions not less than 2,000 registered voters. 2. Provinces and cities not less than 1,000 registered voters. 3. Municipalities not less than 100 registered voters. 4. Barangays not less than 50 may file a petition with the regional assembly or local legislative body, respectively, proposing the adoption, enactment, repeal, or amendment of any law, ordinance or resolution. Seconds. 13. RA 6735. Question: what are the limitations on local initiative? Answer: 1. The power of local initiative shall not be exercised more than once a year. 2. Initiative shall extend only to subjects or matters which are within the legal powers of the local legislative bodies to enact, and 3. If any time before the initiative is held, the local legislative body shall adopt in toto the proposition presented, the initiative shall be cancelled. However, those against such action may, if they so desire, apply for initiative. Question: is the initiative to change the Constitution applicable to revision? Answer: no. An initiative to change the Constitution applies only to an amendment. Revision broadly implies a change that alters basic principle in the Constitution, like altering the principle of separation of powers or the system of checks and balance. The initiative of the petitioners is a revision and not merely an amendment. Lambino v. Cumlic, October 25, 2006. Question: what is referendum? Answer: it is the power of the electorate to approve or reject legislation through an election called for that purpose. Question: what are the two classes of referendum? Answer: 1. Referendum on statutes refers to a petition to approve or reject a law, or part thereof, passed by Congress. 2. Referendum on local law refers to a petition to approve or reject a law, resolution, or ordinance enacted by regional assemblies and local legislative bodies. Notes: the following cannot be subject of an initiative or referendum. 1. Petition embracing more than one subject shall be submitted to the electorate. 2. Statutes involving emergency measures, the enactment of which is specifically vested in Congress by the Constitution, cannot be subject to referendum until 90 days after their effectivity. Section 10 RA 6735. Question: what constitutional provisions are considered self-executing and non-self-executing? Answer: the following provisions of the Constitution are considered as self-executing. 1. Provisions in the Bill of Rights on arrests, searches, and seizures, the rights of a person under custodial investigation, the rights of an accused, and the privilege against self-incrimination. 2. Fundamental rights of life, liberty, and the protection of property. 3. Provisions forbidding the taking or damaging of property for public use without just compensation. Exception: a constitutional provision is not self-executing where it merely announces a policy and its language empowers the legislature to prescribe the means by which the policy shall be carried into effect. 1. Article 2 on Declaration of Principles and State Policies. 2. Article 13 on Social Justice and Human Rights, 3. Article 14 on Education, Science and Technology, Arts, Culture and Sports, Manila Prince Hotel VGSIS, February 3, 1997. Question: what is territory? Answer: territory is the fixed portion of the surface of the earth inhabited by the people of the state. As an element of a state, it is an area over which a state has effective control. Question: what comprises the Philippine territory? Answer: 1. The Philippine archipelago, that body of water studded with islands which is delineated in the Treaty of Paris, as amended by the Treaty of Washington and the Treaty with Great 2. All other territories over which the Philippines has sovereignty or jurisdiction includes any territory that presently belongs or might in the future belong to the Philippines through any of the accepted international modes of acquiring territory. Question: what are the components of our national territory? Answer: 1. Terrestrial domain, 2. Maritime domain, 3. Aerial domain. Note: RA 9522, which was approved by President Arroyo on March 10, 2009, amended certain provisions of RA 3046, as amended by RA 5446, and defined the archipelagic baselines of the Philippines. Question: what is an archipelagic state? Answer: it is a state constituted wholly by one or more archipelagos and may include other islands. Question: what is the Archipelagic Doctrine and where is it found in the 1987 Philippine Constitution? Answer: it is defined as all waters, around, between and connecting different islands belonging to the Philippine archipelago, irrespective of their width or dimension, are necessary appurtenances of its land territory, forming an integral part of the national or inland waters, subject to the exclusive sovereignty of the Philippines. It is found in the second sentence of Article 1 of the 1987 Constitution. Question: what does the Archipelagic Doctrine emphasize? Answer: it emphasizes the unity of the land and waters by defining an archipelago as group of islands surrounded by waters or a body of waters studded with islands. Note: to emphasize unity, an imaginary single baseline is drawn around the islands by joining appropriate points of the outermost islands of the archipelago with straight lines, and all islands and waters enclosed within the baseline form part of its territory. Question: what are the purposes of the Archipelagic Doctrine? Answer: the following are the purposes of the Archipelagic Doctrine. 1. Territorial integrity. 2. National security. 3. Economic reasons. Note: the main purpose of the Archipelagic Doctrine is to protect the territorial interests of an archipelago, that is, to protect the territorial integrity of the archipelago. Without it, there would be pockets of high seas between some of our islands and islets. Thus foreign vessels would be able to pass through these pockets of seas and would have no jurisdiction over them. Accordingly, if we follow the old rule of international law, it is possible that between islands, e.g. Bohol and Siquijor, due to the more than 24-mile distance between the two islands, there may be high seas. Thus, foreign vessels may just enter any time at will, posing danger to the security of the state. However, applying the doctrine, even these bodies of water within the baseline, regardless of breadth, form part of the archipelago and are thus considered as internal waters. Question: is the Spratlys Group of Islands, SGI, part of the Philippine archipelago? Answer: no. It is too far to be included within the archipelagic lines encircling the internal waters of Philippine archipelago. However, the SGI is part of the Philippine territory because it was discovered by a Filipino seaman in the name of Vice Admiral Cloma, who later renounced his claim over it in favor of the Republic of the Philippines. Subsequently, then Pres. Marcos issued a presidential decree constituting SGI as part of the Philippine territory and sending some of our armed forces to protect